Welcome to a special Sunday edition of Anglican Unscripted. I'm here with Alan Haley. We're going to talk legal talk, the most exciting topic you can watch on Anglican Unscripted. I'm Kevin Carlson.
And I'm Alan Haley. And today is February 22nd, 2015, George Washington's birthday.
Why would two guys sit down on a Sunday to talk about law? Well, we actually have some exciting news that Alan's going to talk about. To us, exciting news is when the Episcopal Church either loses in court, gives up in court, or gets slapped by a judge. In this case, they got slapped by a judge. Tell me let's do a little background. We're going to talk about what happened in St. Louis and Illinois. Give me the background before you give the big cliffhanger.
No problem.
All right.
Okay, well, this is a lawsuit that had been going on in Quincy, Illinois, the Diocese of Quincy, and ever since 2009, when the Episcopal Church attorneys at 815 2nd Avenue wrote a letter to the PNC Bank in Quincy, which holds the funds of the diocese in trust, and saying that the better freeze those funds, because the diocese had made moves toward changing its constitution and withdrawing from the church. So the church actually promptly, in the face of litigation threat from the Episcopal Church, froze the funds. And they remained frozen all through the lawsuit. The lawsuit finally went to trial last year, actually the year before last, and then the judge ruled, after looking at all of text documents, that there's no rule, no canon that says a diocese can't amend its governing documents to withdraw from the church. So, therefore, he held that all the funds in the bank account belonged to the Anglican Diocese of Quincy. That went up on appeal to the Court of Appeals in Peoria, and they came out with a decision last July saying that indeed the trial court was correct. We've examined the documents too. There's no rule preventing a diocese from withdrawing. And so therefore we affirm the judgment. All the funds belong to the Diocese of Quincy.
So just to make it clear here, according to the courts, the plaintiff won.
Yes.
Okay. So
and now what happened after that? Well, first the Episcopal Church tried a Hail Mary pass up to the Illinois Supreme Court.
Right.
That didn't work. It turned down the request for review in November. Now, then what happened? So that on December 31st, the Supreme Court said we will send the mandate back to the Court of Appeal on December 31st. Well, that meant when the mandate comes back from the higher court, then the lower court has jurisdiction, and then the appellate court would send it back to the trial court. And that's how things get back down to the trial court, where we can get the judgment entered, and Quincy wanted to get its funds out of the bank and get them unfrozen. Well, on December 30th, the day before the Illinois Supreme Court was supposed to send its mandate down, the Episcopal Church lawyers sent another letter to the bank and saying, about those funds that are on deposit that you've been ordered to return to the Anglican Diocese. It seems there are about $800,000 in there that we think belong to one of the parishes in that diocese that had no right to take them from the Episcopal Church. And we've got another lawsuit pending in Peoria in a different court. And we're going to be claiming those funds in that lawsuit, so you would do best not to let them out of your possession.
Now, in the real world, they can get away with this type of stuff. This is kind of what
happens
away with
it all the time.
This happens behind the scenes. It never makes it to a judge. It's just something that happens, and you're stuck for a while having to deal with it. Fortunately, in the Diocese of Quincy, they have some incredible lawyers.
Yes.
Let's talk about them real quick.
Okay. Yeah, Tad Brenner and Kent Snack. And both of them are outstanding. They've been doing this litigation for years without any getting paid because all the funds were frozen. And now finally they've looked at getting some of the funds back so that they could at last collect a little bit of their fees. And once again, the funds are frozen. So they go in on motions. Tad represents Bishop Alberto Morales and Kent represents the diocese. And they go in on motions to enforce the judgment and to have the court order the funds be paid out, because according with the judgment. Now, there's a new judge on the bench. It's not the same judge 2 years later who tried the case. And so they have to educate him. And they filed the papers necessary to bring him up to speed on everything. And then he held a hearing last week and ruled from the bench that this was outrageous, that these funds should have come out, and the Episcopal Church had no business laying claim to them. And then he issued a written ruling following up on his oral ruling.
Well, hold on. You say it's a written ruling. In my dictionary, it's called a spanking. But let's go on with what you...
Well, yeah okay. Yeah, and it's very interesting because what he did was his ruling from the bench was just verbal and was a sort of a tongue lashing, but the written decision got right down to the heart of things. It starts right off saying, in case we hadn't been clear enough in the earlier decision, we'll make it clear now, plaintiffs won. Now, for a court to start out a decision like that is, as you can imagine, is a real, I would hate to be on the receiving end of something like that, because it's making it clear that what happened was the Episcopal Church, of course, tried the Quincy case all along about a single bank account. They never said there were separate funds in the account that belonged to different parishes and we want to segregate those out. It was just a litigation over this single bank account in which there were a couple of $1 million. And the case went all the way up on appeal. It was still regarded as the same bank account. They never raised the issue about this. And so the trial court slammed them for saying, this judgment is now final. These funds, all of them, by the courts, have ruled now belong to the Anglican diocese. You can't come in and all of a sudden start saying that, well, some of them don't. You should have brought that claim into the trial court. And they hadn't, of course. And so the trial court now said, not only do you have to pay all of Tad's and Kent's attorney's fees from December 30th, and whatever reasonable hours they've had to put on this, that's what you're going to pay. And furthermore, I'm going to issue an injunction ordering you to cease and desist.
That just feels
making
good.
Any claim.
Oh.
That's right. Making any claim that these funds belong to anybody but the Anglican Diocese of Quincy. And so now that they've been ordered and an injunction put against them, if they dare disobey that, then that's going to be a case, of course, for contempt of court. But this is, modus operandi, standard procedure for the Episcopal Church in any of these diocesan lawsuits. We know now because of the pattern established first in San Joaquin. The very first thing they do is they send a letter to the diocese's bank in order to freeze the funds. The next thing they do is they get a rump group going in order to be a plaintiff in a lawsuit and to claim the funds. And that's what happened in all the cases in San Joaquin, in Fort Worth, in Quincy, and then, however, in South Carolina, they were one up on the Episcopal Church. They'd seen what had happened, and they didn't tell the Episcopal Church or let them know where their funds were, so there was no freeze on there in South Carolina.
But South Carolina was the first time that there was a different legal tactic. In South Carolina, the diocese decided, we're going to meet you in court first.
That's right. And we're going to seize the initiative and take away your right to pretend that you're us. And got an injunction right off the bat against using a confusing name.
So we have a complete resolution in South Carolina within a year, where you're still fighting San Joaquin. After 7 years, you're still fighting Diocese of Fort Worth. After 6 years, it's any other diocese, Albany, anybody else who wants to leave, you have to sue to get out.
Right.
It's
although pretty soon it's going to be pretty clear, and enough of these cases come out. The Illinois case, and now we're going to have the Texas decision here any day now from the Judge Chupp there in the trial court. We're also going to, of course, on appeal in the San Joaquin case. It'll be a while before we get the ruling on that. But I think there's going to be enough rulings coming out saying that dioceses can leave the church. That's going to undermine the whole polity of the Episcopal Church for quite some time, because it means that they can't really go to court to stop it. Once you've lost a fight like this in Illinois, for example, you're not allowed to come into court and keep saying over and over again, well, but they can't leave, they can't leave. Now, you've got to change your governing documents if you want that to happen. And even if they tried to pass a provision in the Constitution saying dioceses are perpetually bound and cannot leave, that would violate the First Amendment freedom of association of the dioceses. So, I mean, we have to distinguish between and this is lost on a lot of people, distinguish between a secular law regime and an ecclesiastical law regime. The ecclesiastical law is how the churches govern themselves, and they can make ecclesiastical laws called canons and everything like that, and nobody can tell them what not to do because that's part of their exercise of their religion. But on the secular side, they have to comply, just by everybody else does, with the local civil laws. So there's those two things. They can say ecclesiastically, a diocese may never leave a church. That's an ecclesiastical union, which of course would violate moral laws and God's law if it was broken. But in civilly, they can't say that because that violates the First Amendment of the U.S. Constitution, to which they and all other churches are subject.
Well,
so
for the
that's
longest
the problem.
for the longest time, and you probably heard this in law school, you were told not to touch ecclesial cases because you just don't want to go there. Let the church decide what the church does. Let the U.S. Constitution decides what everybody else does. And
again, that's part of the First Amendment,
right,
too.
and judges would not take a church fight claim. It happened with the Mormons. It happened with the Latter-day Saints. They never wanted to go in and make any decision whatsoever for the church because it's like the third rail of jurisprudence.
Yeah, the First Amendment includes, among freedom of religion, freedom of exercise of religion. So therefore, the courts are not allowed. The secular courts are not allowed to go in and decide who should be the bishop of this church or who. If a clergy discipline was correct or anything like that. They can't get involved in ecclesiastical matters. That's the other side of the First Amendment. But it's a two-way thing. That just as the secular courts can't involve themselves in ecclesiastical matters, so the churches are not able to go in and change secular law just for their own benefit and say, well, we don't have to comply with for example, the law of trust. If we want to create a trust in a parish property, we'll get the parish to sign a document under state law, record it, and then there's a trust. That's how you comply. You don't simply say up here, we'll pass a canon, ecclesiastical canon, and say automatically all these properties are in trust for us. That's not kosher, and that's not the way the civil law requires it. So that's what's been going on here. The Episcopal Church for too long has tried to get away with not being subject to the normal laws that everybody else is.
Okay. Next thing coming up is the Fort Worth decision. Sometime, check your calendar. When are you on vacation?
Right. next time in March sometime.
Oh, I won't wait that long. Yeah. Sometime in the next week or two, we're going to hear about the Diocese of Fort Worth, assuming based on some of the precedents set with their Supreme Court, neutral principles will apply. Fort Worth will get their money in the property. Am I right?
Well, it seems like there was one case the judge carved out, the All Saints Church. Which is one of the wealthiest churches in the revisionist rump group of Fort Worth. And so that suit's going to be tried separately to a jury toward the end of March. I think it's because it's a corporation and it owns some parcels of property that are separate from whatever is in the diocesan corporation. But anyway, that's going to be probably a separate case, but the rest of it should all be decided right. I have just put up a summary of the whole litigation calendar of the Episcopal Church, the annual 2015 review, and I would send anyone there for all the details.
Yeah, I'll put a link here. Right, if you're looking at the YouTube page right now watching us, there's a link to Alan's story. Let's talk real quick here. You're doing a summary. You got some 90 cases, 80 some by the Episcopal Church. And I asked you this in the pre-show. Is there a way that we can get a line-by-line accounting of how much these lawsuits cost? And you said it was tried before by some bishops, but they got a letter back saying they don't have the authority to ask for that. Why isn't there more accounting within this church?
Well, General Convention has the authority, of course, if it would exercise it. It was there was a motion on the floor of General Convention a couple of years ago, one of the deputies asking for an accounting of what had been spent on the lawsuits, and it was shouted down on the grounds that this would be bad information to give to the other side. I'm sorry. When it's gotten so out of control that you don't know how much you're spending, and this spending is amounted to upwards of in excess of $40 million, that's no longer something that you should keep hidden from all the delegates to General Convention. And so that's why, or the deputies, I guess,
Right.
I
Yeah.
use the correct terminology, but
That's
the
all right.
deputies.
I just compared Mormons to Latter-day Saints, so
Uh,
you could do you could do
in any event,
likewise.
the deputies have the power to demand this information. They go through the budget. Of course, they go through it very quickly, but they can break out line items and say, "What's all this about?" And the other thing that's going to happen between now and General Convention, Kevin, is I predict the Episcopal Church is going to get hit with a bill of at least $1 million, maybe more, in attorney's fees in the South Carolina case for all the extra legal work they cost by dragging the case over to federal court on the trademark stuff and all that. South Carolina awards attorney's fees for that kind of conduct, and this is going to be a huge bill, and they're going to have to make a special budget adjustment for it.
Is there any way somebody from the floor can this time around ask for an accounting a line item? I guess you would help craft the language for that resolution on your spare time. But now you're a lawyer. You can't make this advice to the Episcopal Church. I can because I'm not a lawyer. I've never passed a bar. I recommend the Episcopal Church completely ignore what happened in Illinois. Continue to seek the bank to shut down the money. Keep calling PNC and forcing them not to give the money to the Anglican diocese. That's just my recommendation. Alan, thank you so much for your time on a Sunday.
Kevin, we have to insert one footnote in there.
Yeah.
This time, I really have to disclaim myself from your advice, which is fine.
Yeah.
That's your advice.
That's my advice.
But I have no part to do with that Episcopal Church. Please do not quote this program as saying, I have now urged all this kind of bad behavior against the court. Because you remember the last time we talked
That's
about
right.
the funds being frozen, immediately the Episcopal Church picked up on your question, which I said, no, they can't start writing checks right away. But the Episcopal Church was good enough saying, oh, they're going to go start spending all the money. And they quoted and then one of their own attorneys has said this, Anyway, so I have to strongly dissociate myself from your last remarks.
Please do, because as a lawyer, you have gotten no lower in your legalese than to play for the judge a tape of Kevin and Alan talking about a court decision. That's as low as it goes. I heard about that too. That was something else.
Right.
Alan, thank you for your time. I'm Kevin Carlson.
Okay, and I'm Alan Haley.